Good morning, everyone. Today is Tuesday, September 1st. I'm Ann Koontz. I'm here with my partners, Jackie Durham and Marina Parkin. As always, we are trying to bring you interesting and relevant business and real estate and tax topics from both legal and tax perspective, accounting perspective. We have quite a tag team here today. So this morning, we wanted to talk about commercial leases, and we're talking about them really from a tenant perspective today. There are different considerations to make if you are the landlord, but today we wanted to talk about it from the tenant perspective. Whether you're already involved in a commercial lease, looking at a renewal, considering leaving a job and starting a business where you might need a lease, we wanted to kind of go over some of the considerations that are frequently overlooked, some of the times that we surprise people when we review a commercial lease or draft one. Oftentimes we hear comments about why it takes so long or why there are so many pages. And frequently I hear my favorite, which is, it shouldn't take you long, it's only 3 pages.
Yes.
If something like
take me 3 times as long.
If something like a commercial lease or an operating agreement or something for your business is 3 pages, I promise it's not enough, and I haven't even read it. So what's not being said is oftentimes more detrimental than the provisions that might actually be contained in the agreement. So don't be fooled by something simple or boilerplate. I would say as a general proposition, that's another place where people feel like they're coming from a position of strength if they say, well, this is the standard agreement, whether it's a contract or a lease or any, operating agreement, anything. People go, oh, it doesn't, this is probably fine, it's standard. Standard is not customized to your circumstances, and that's really not really where so many problems come from necessarily. It's where so many surprise problems come from. Probably the number of problems that's possible is relatively the same. But when you haven't bothered to read it, you tend to be more surprised. So oftentimes when we review agreements like this, or construction agreements, we're a little bit Katie Couric, where we just deliver the news. Sometimes you may not be able to change it, but at least you know what you're getting into rather than finding out after the fact. So without further ado, I'll turn it over to Jackie to drop the first bomb on us on commercial lease situations that you've encountered.
Right. And I will say that a lot of these horror stories that we're going to share today are a result of clients coming to us after the fact and having us review their leases when the problem arises. So I really feel like they shouldn't be an afterthought, that it's really important that you can avoid some of the issues we're going to talk about today by just having an attorney review it in advance so that you know what you're walking into and you can avoid certain things. So I guess,
and hopefully a real estate attorney, not like your cousin who's a family lawyer in California when the property's in Florida, because that's always fun when those folks are on the other side. Right.
So I guess the first item that we'll touch on, because there's a lot, and we might have to do a part 2 of this maybe. So the first item we'll touch on is just making sure, first and foremost, that the landlord listed on the lease is correct. So I can't tell you the number of times that I have reviewed a lease and I go into public record to see who the legal title holder is of the property, and they don't match. And oftentimes it might be because a corporation or LLC owns the property, but just the owner of that particular entity is signing off on the lease. Well, that's not valid to bind the actual title holder of the property. So you need to make sure that those parties match. And also you want to make sure that whoever's signing off on the lease has the proper authority to do so. So in public record, in some biz, there are managers or officers listed that are able to act on behalf of the company. If that person or one of those persons is not signing the lease, you might want to request some kind of written confirmation that the person who is signing off on behalf of the landlord actually holds that authority. Because if they don't, then the lease is not legally binding against the landlord. And the other thing I wanted to mention is the leases also sometimes contain only one landlord when there might actually be 2 title holders. And this can be problematic again, because if you need to pursue any kind of recourse against the landlord, you only have one of the owners that has signed off on this. So if you need to pursue remedies against the property or things like that, you might be prevented from doing so because not both landlords have actually signed off on this lease. So I don't know how often you've seen that, Joanne, but I feel like I bump into that pretty often.
I see that. The thing I see probably more commonly is what you said, where the landlord is not the title owner. And that really, where I see that happen is because people run out and they form an LLC because, I don't know, maybe they listened to our webinar and heard it was a great idea, but they don't take step 2, which is to actually title deed the property from yourself to the LLC. So oftentimes the landlord believes they are the landlord, but they are not because they haven't done anything to effectuate that change of title ownership. That happens residential and commercial frequently.
Yeah.
And it's bad news on both sides.
Right, exactly. Another thing that I would like to mention is that, and this is typically included in leases, but it's a really good tool for a tenant to have, is to make sure you try to negotiate as best as possible the longest and the most number of extension terms that you can obtain with the landlord. So this is really good for tenants, I think, because if you get into the lease and you decide that the space is not right for you, you can pay out the rest of your term and then leave. But if it turns out to be a really good space for your business, if you have some extension terms that are locked in there with locked in rates, that can really benefit you and allow you to stay in the property for that much longer, which will benefit your business. So
Definitely.
The other thing I wanted to touch on, we were talking about this recently, Joanne, especially if you're a tenant in a shopping center, almost all of these leases are going to reserve the right to the landlord to move you to an alternative space within the shopping center or within one of their sister shopping centers nearby. So this can raise a couple of problems because, number one, they can move you to basically whatever spot they want. So you may be going into a lease in a particular location of the shopping center that is desirable to you for whatever reason, and then they can relocate you to an alternative location that is less desirable, less marketable. And another problem that I've seen clients run into is they move into a location, they dump 30 grand into tenant improvements, and then they have to be removed 2 years later. Well, nothing in the lease says that the landlord has to make you whole or contribute to your loss in that way when you have to go into the new space and complete new tenant improvements. So I always try to make sure that we negotiate something into the lease that provides for how is the tenant going to be made whole if they have to redo all of their tenant improvements, and also what's going to happen during the period of time while those tenant improvements have to be made, because you might have a slight interruption in business, which is another reason why, you know, we always encourage business interruption insurance, which we'll kind of touch on later, but there's a number of reasons for that as well. So I know you've seen that, Joanne, I think, in a number of clients.
It has happened several times, and sometimes the space that they're going to put you in may not be as favorable from a frontage standpoint or foot traffic or signage or maybe a symbiotic relationship. So you might have a chiropractor right next door to an acupuncturist. And if it's very helpful for those two businesses to live side by side, if you put the acupuncturist next to the ice cream shop, they might see a decline in revenue, and you don't really have any recourse against that. So a little bit of that may fall in that category of there's not much you can do. You're going to have a tough time getting a landlord to pull that out of a lease completely. And the other thing that you might want to try to do is tighten that up. So what is the reason why they're moving you? Maybe they just can lease your space for more, or the next door tenant wants to expand and needs more space. You don't always have control over what that reason is, but it happens more frequently than you think. I'm not trying to suggest it's, 50% of leases. It's not, but it's a horrible disruption. It's costly. It's costly in time and money, and the friction of, people finding you, and depending on where that is, and redoing all the marketing and just changing everything in Google is horrible. I know our firm still shows up at our old Main Street location, and we've been here 4 years. So getting Google to unlearn something sometimes is hard too. And those are silly things that are small in terms of scope compared to the lease, but they are what keeps the business owner aggravated through the process. It's bad enough you have to do it. Now you've got all this sort of side effect trickle down that you continue to deal with weeks after you're into the new space.
Right, exactly. And, I feel like sometimes business owners just having to reach out to clients and notify everybody, hey, this is where we're going. We're right around the corner. we haven't gone far, it still will disrupt the business, at least for an initial period of time.
Just the time you're on the phone calling those people is annoying.
Yeah, yeah, exactly. The other item that I wanted to also touch on that I think is really important that a lot of tenants overlook, and it can come back to kind of bite them later in the lease, is the scope of the maintenance and repair of the property itself. So in most commercial leases, the landlord is only going to be responsible for maintaining the roof, the foundation, and the exterior walls. So you as the commercial tenant are going to be responsible for maintaining, repairing, and replacing all the other systems. So it's really important that you get a professional inspection of the property before signing the lease, because it never fails that whenever a client listens to me, they get a professional inspection. They come back with a laundry list of things that the landlord needs to correct before they step foot into that lease. The problem is the lease is going to say, I, landlord, am warranting nothing about the property. You're accepting the property as it is. So if you don't have a professional inspector go in there and make sure that everything is okay under the hood, you might be stepping into a number of problems. And if you have a 5 or 10 year lease, you know, there could be a number of problems that you encounter just due to the life and age of certain systems. So you want to know what the life and age of the HVAC is. You want to know sort of what you're stepping into and what those expenses may look like, because you may get some kind of financial accommodation from the landlord when you bring it to them in black and white and show them what the inspection report has said. The other really important factor that I've seen kind of come back and cause problems for clients is also the actual scope of repair as it pertains to the particular systems. So for instance, if you're required to maintain and repair plumbing and electrical systems, you have to think that the utility lines for these systems extends out beyond the actual premises itself. And many of these leases are written in a way that's sort of loosey-goosey. And I've had clients with landlords who have come to them with their hand out saying, hey, there's a problem with the plumbing line. And the tenant has looked into it, and the plumbing line is far out beyond their actual premises. But the landlord is still fighting them on it, and they're still having to pay an attorney to fight back against this, and the lease is clear as mud. So in my leases, I typically always try to make sure that we put in a clause that very clearly states that the tenant's obligation for these utilities and these systems starts at the point at which they begin to directly serve the premises. So just something, again, that sort of tends to be an afterthought that can really cause some problems and expense for tenants if they're not careful.
How much pushback do you think you get on a regular basis from landlords when you try to add that language in?
Not a lot.
Yeah.
Honestly, I think most landlords, as
Don't
long
think
as
it's
they
gonna
have
be a problem.
yeah, as long as they have an attorney on the other side, the attorney's like, yeah, that's fair. If they don't, some landlords have the form that their attorney has prepared, and they're like, this is it, take it or leave it. At which point, you know, your client as a tenant has to sort of decide what their appetite for risk is.
Right.
Like you said, we kind of educate the client on these are the risks. We can push back on some of them. If we don't get them, at least you know what you're stepping into and what risks you're assuming. So.
Let me also jump in on the tax side of this particular issue a little bit, in that when I prepare a tax return for an entity, we often look at the lease agreement to determine who gets to deduct and write off and how these tenant improvements.
Mm-hmm.
So whether it's the landlord's tax return that we're doing or the tenant's tax return, we always look at it. And if the language is very loose around who pays, it's really hard for us to figure out what is properly deductible. Mm-hmm. Because if the language clearly states that the landlord only provides a certain amount, then we can certainly deduct that amount for the landlord. But if we then pull up their books for tax return and we realize that actually the landlord undertook the expenses and did the improvements themselves instead of just providing funds to the tenant, then it becomes a completely different tax issue. Mm-hmm. And then they realize that maybe instead of being able to deduct this as some sort of incentive pay to the tenant, they now have to capitalize and depreciate the improvement. If they fall into a section where they may not be able to take 100% depreciation on it, now they're not quite getting the tax benefit. And same goes for the tenant. When we're looking at the books, it's the same thing. Are you the one doing the improvement? If so, then we have different depreciation treatment on the improvements, or are you, just receiving the money? So this really drives the tax treatment. And this is why it's very important for us to get the lease agreement that's got very clear language for both sides on who is paying for what.
Yep, good point. I guess the next point that we wanted to touch on as well is the default remedies that are provided to a landlord. So most of these commercial leases are very drafted heavily in favor of the landlord for obvious reasons. And so the landlord has all the remedies under the sun. So they can collect the balance of the rent that is due to the end of the lease term, even if you default. And mention a new fee that I'm seeing coming into the mix recently and more frequently is liquidated damages. So in addition to all of those damages that I just mentioned, on top of that, some commercial tenants will also be required to pay 20 to 30% in addition to the balance of the rental due under the lease, which can be substantial. So it's important to note that. And I always try to, of course, at first negotiate it completely out of the lease. I typically get the pushback, at which point we try to negotiate it down to an amount that a tenant is comfortable with. But it's really important to note something like that, because it just adds insult to injury. If you're a tenant and for whatever reason your business is not doing well and you're unable to meet your obligations under the lease, having to pay that kind of penalty on top of that would be very disappointing. So just make sure you note things like that in the default provisions, because they can kind of sink in there. And I really haven't noticed them before until recently.
And whether it's a lease or a purchase agreement, I oftentimes see people very eager to write in requirements. You have to do this, the buyer has to do that, the tenant has to do that, the seller has to do this, but nobody wants to say what happens if you don't. And so the default provision is one of the first paragraphs that we address in any agreement, because people have a tendency when they're putting a deal together, and the parties themselves are very good about laying out who needs to do what, but not very good about laying out what happens when somebody doesn't.
Right, exactly. And it's another thing I would like to note is that although the landlord is reserving a number of remedies for themselves, they really reserve none for the tenant. And it can be really difficult for a tenant to enforce their rights if and when there is a default by the landlord. So something else I always recommend is that we at least propose that there be some kind of termination provision in favor of the tenant in the event the landlord defaults and doesn't cure this default. And I'll give you an example of why. I had a tenant client who was occupying a space, paying rent on time, had been there for several years, was a very good tenant. All of a sudden, the landlord literally, without notice, took down one of their walls and expanded the adjacent lease space into their space without their permission, without their sign off, and without any kind of abatement of rent. So I did not review this lease for the client in advance, unfortunately, and they brought me the lease and said, what can we do? Well, of course, what was not in the lease was their ability to terminate the lease. So when you don't have the ability to terminate the lease as the tenant, what are your options? Well, you have to go to court and get a judgment terminating the lease, which means you have to hire an attorney, sue the landlord, and terminate the lease by way of that recourse. And to add insult to injury, oftentimes in these commercial leases, the only remedy available to a tenant is the landlord's interest in the property. So you can't pursue the landlord for personal damages. You can only pursue the property. Well, if the property's mortgaged and there's no value left in the property, you can't pull water from a rock. So now as a tenant, you've had to pay thousands of dollars to terminate the lease, which wasn't your fault, and you have no recourse essentially against the landlord. So that's why I'm a big proponent of making sure that a tenant can also terminate the lease provisions as well, or terminate the lease as well if there's a landlord default. Let me see what else. Oh, Another big item I wanted to talk about is the assumption of risk under the lease. So I think the clause, Joanne, I'm sure you'll agree with me, the clause that I think we negotiate the hardest is the indemnification provision. So undoubtedly in your lease, the landlord is going to provide that you're going to hold them harmless and indemnify them for everything under the sun, including their own negligent acts and omissions. So the problem with that is you are agreeing to indemnify the landlord and pay the damages and expenses resulting from acts and omissions that are completely outside of your control. That's problematic in and of itself. Yeah. However, something else that's problematic that a lot of tenants are a little surprised by is your commercial general liability coverage is not going to extend to that indemnification liability. You cannot change your insurance contract by way of your lease agreement. So you might have an unfortunate surprise when you go to make a claim under your CGL and they're like, you may have agreed to assume this risk under the lease agreement, but that's not our problem. Mm-hmm. So it's really important to try to mitigate that. I try to pull it out altogether. I would say 50 to 60% of the time I'm successful in that because it's reasonable. Why am I going to indemnify you, landlord, for your negligent acts and omissions? So. Mm-hmm.
Yeah, but they sure do try.
Oh, they always try. And it looks like, and I'm talking about there's a couple little words that you can pull out or put in that can make a huge difference. Mm-hmm. So if you don't have an attorney looking at it, it's really easy to think, oh, this looks normal. Mm-hmm. And that's, of course, what the landlord wants. And I don't blame them.
Yeah, bury it in the boilerplate is really
right, exactly. Let me see. We were also going to talk, I think, Joanne, about the fact that under most of these leases, you have an obligation as a tenant, regardless of what's going on with your business or in your personal life, you have an obligation to continuously operate in that space. Otherwise, it is a default under the lease. Mm-hmm. This can be an issue for a number of reasons. More recently, a pandemic. So you have a force majeure provision that says that if you fail to perform because of a hurricane or lightning or hostile takeover, that you are excused from that non-performance or breach under the lease. However, these force majeure provisions can be pretty narrow. So you need to make sure that you're broadening those as far as possible to make sure that if you are incapable of operating in the space, you're not ultimately deemed and default of the lease as well. And I think you've seen locally, Joanne, some instances where this has become a problem for tenants.
Definitely. I had a situation in the last, couple years where, especially once the economy was a little bit softer than it even is now, you would see some stores who were in a particular shopping plaza that just don't lend themselves to be like evening types of places. They're places that the public generally is not frequenting in the evening. So those folks would get lumped in with businesses that, maybe an ice cream shop is going to be open till 9 or 10 o'clock at night. But maybe it doesn't make sense that the yoga studio is open that late, for example. So if you say all of these businesses have to be treated the same and they don't take into consideration the type of business, I get it from the landlord's perspective. Nobody wants to go to a place that's half closed. So the landlords are trying to put this in there to make sure that it's hustle and bustle and that people want to come to the shopping plaza. However, if you are now paying an employee just to stand there and Facebook because there's not going to be any customers, but you just have to have a light on to be open to avoid default, that gets costly. Not to mention that it's not good for your business to be standing there looking dead as a doornail. So people go, oh, nobody's in there, it must not be good. And so much of perception does control. People will go to a busy restaurant because it's busy, it must be good. And avoid a place that's not busy and have no idea if it's good or not, but just avoid it because it's dead. You don't want to be the first table seated in a restaurant, unless it's early bird or happy hour. But it can put a financial strain. It can also, lead to losses where there's inventory shrinkage or maybe theft because the business is not being minded in the evening like it maybe should be. So, the nature of the business that's going to live in that space is something that you need to consider in many of the lease provisions, but particularly this one.
Right. Something else that I want to just jump back to that I wanted to mention earlier, mm-hmm. When we're talking about a default on the part of the landlord, keep in mind, because I feel like clients a lot of times do this and they come to me after the fact and say, oh, well, the landlord did this, so I just stopped paying rent, right? Mm-hmm. They're wrong, so I can be wrong too. Well, keep in mind that under most of these leases, it specifically restricts a tenant from being able to do that. You can't offset rent. You are obligated to continue paying rent, even if you believe the landlord to be in default.
Mm-hmm.
And another issue that can arise is if you stop paying rent and the landlord then takes you to court for failure to pay rent, many times the lease also restricts you from filing a counterclaim in that action to offset the damages that the landlord's claiming. So now they're suing you and you have to go in a separate lawsuit and sue them. And it can just make things a lot more difficult. So I would strongly encourage clients to continue paying rent until you know for sure from your attorney that you have a right to offset that rent. Just wanted to go back to that.
Yeah, that does happen quite a bit, and rings true with lots of things where you have, well, they're already wrong. Call first before you decide how you're righting the wrong, because that can get expensive quickly.
Right.
What is your guys' recommendation generally if you do want to confront your landlord on certain things that, are no longer working, or you may want to change some terms of the lease? Do you need to lawyer up? Would you recommend talking to the landlord directly? What's been the thing that you guys see kind of the most?
I think it depends on who the landlord is and the relationship with the tenant. So are you with, a huge company landlord where you don't even know how to get to the top? Are you with mom and pop? Does your landlord business live in the business next door? So first place I would start is to evaluate the nature of that relationship. Not everything needs to start with a lawyer. What you might want to do is consult with your lawyer before you ask for something that might not be helping you, because sometimes people have decided, I'm going to go get this. One thing that I see people underappreciate is the value in being able to stay. Oftentimes people don't want to feel handcuffed to a lease. So like, I don't want too long of a term. But if you flip that script around and say, well, what about if things are going great and your business is going well and you don't want to have to leave? So, maybe if you're going to ask for something, you want to give something in return to make this enticing for the landlord to accept your modification. Maybe a modification that an alternate option that we can suggest might actually benefit you as well. So you may not necessarily need a lawyer to propose your changes, but you might want to speak with your lawyer before you ask for something that isn't exactly what you want. Might have some side impact that you don't necessarily think of. And then once you all have agreed to it, then maybe you want your lawyer to draft the amendment to the lease.
Right. Yeah, it's always good to strategize about those things before going in, because sometimes you don't want to necessarily show your cards.
Yeah.
So that's a good point.
And it's like if you are asking for maybe more improvements, like, hey, I had a gym once that was like, we really need another bathroom. The lease probably says that you need to get the landlord's permission to make modifications like that. So in going in with that, landlord's thinking, oh my gosh, leaky pipes, disaster, I don't know if I want to deal with this. Well, you know what, landlord, I'd like to add a bathroom. And then as a result of that, of course, I'm happy to pay for it, but I'd also like to tack on maybe another 3 years to the lease. Landlord's like, great. And you're like, sweet, now I just put all this money in the bathroom. I don't want to have to move again. Maybe it's 5 years, maybe it's 2 renewal terms, but that's something that actually benefits you. But the landlord can be viewing that as, great, I have security now, you're going to stay longer. So, you don't want to just go hat in hand without any idea what the other side might view your relationship, what they might view that request as. So.
Right. Speaking of tenant improvements, I'm just curious. I feel like, and I would say at least half of the leases that I review that involve some kind of tenant improvements or landlord improvements, they're at the back of the lease as an exhibit, and they're kind of an afterthought. And many times they're put together by the broker and not by one of the party's attorneys. And the parties kind of just gloss over this because they're after the signature page. And I already told my broker exactly what I wanted and how many bathrooms I wanted. But many times when the tenant takes a close look at that, there's stuff missing, or it's incorrect, or the bathroom's on the wrong side of the wall, whatever it may be. And many times the rate that you're negotiating into that lease, if there's landlord improvements, is hinging on what's in those improvements themselves. So if you're not getting what you're paying for, that could be really disappointing. So I don't know how often you run into that, Joanne, but I feel like I see it all the time.
Tons. That's something that you nailed it on the head when you said, well, I told my agent. Well, still they're humans, so I would read it because what matters is what you signed, not what you said. So I think that gets overlooked a fair amount of the time, particularly with something with either food service where there's specifications about either the setup, if there's a franchise and the layout is important, or the cooler size, something that's unique. That is really where you definitely need to watch the specifications, because if they just shove the bathroom in this corner and the franchise or requires that it's in the other corner in order to conform with their space layouts, you've got a big problem. And now, not only have you wasted the money on building the bathroom in the wrong place, now you're out of compliance with your franchise agreement, for example.
Right.
We do have a question from Lisa, and she says, how often do landlords require a personal guarantee, and will they accept a good guy guarantee instead? What are your—
Always.
Oh.
They always
Pinky
require
swear.
that.
Just pinky swear that you'll pay. What do you mean?
Yeah. I feel like they do always require a personal guarantee. I've never actually proposed anything other than the tenant's principals to be the guarantors, but that doesn't mean that the landlord won't look at some financials and accept somebody else's personal guarantee. So
yeah, and I will say occasionally I've seen in some smaller, where maybe the landlord just owns one property, or it's not a huge strip mall, not a commercial landlord, mom and pop stuff, where maybe they don't, or maybe they'll let the personal guarantee go after the first term and say, you know what, once you've paid for 5 years, then they won't require it on the renewals, or after a particular level of sales or something like that. That's less common, but typically what I see is either it's not required because it's a small landlord, or it expires after the first term.
Right.
Can you guys touch on the first and last month rent? I get across that issue quite a bit on the tax side, because for a landlord, we need to figure out, is it taxable when you collect it, or is it not taxable? And for the tenant, if I'm doing the tenant's tax return, is it deductible or not deductible? So on the tax side, we have fairly good guidance about, if it's written in a way that when I collect first month rent, but I do not have to return it, then it becomes taxable, because I don't have to provide any more, services or anything like that. But if it's collected and it will apply towards the truly last month rent, then I actually haven't yet received it as taxable income, and I only put it in the income when the lease ends. But sometimes the wording gets a little gray, and we gotta have to make our best assumption and work with the parties. So tell me what your thoughts are on there, and how you would prefer to write those things.
Well, I think the way those are, they're pretty straightforward. You're paying for obviously your first month of rent, and then the final month of rent, whether that's at the natural expiration of the term, or if there is a negotiation of a termination of the lease early. So it's going to apply to that no matter what. I think that it sounds like I would be curious though, from a tax standpoint, when it's paid, if it's deemed already earned by the landlord, and therefore the tenant can also include that with what they've paid in rental expenses for the year. I don't know about that from a tax standpoint, but if under the lease, I guess I would consider that paid and not just reserved off to the side.
Yeah, other than security
on the
deposit.
tax side.
Go ahead.
Yeah, exactly. If it's really just written more of a security deposit where you still have to perform an obligation essentially to really earn it, then it's technically not really your income yet.
Mm-hmm.
But if there's any wording in the lease that says, I got it, and no matter what happens, I don't have to give that back, then you've essentially earned it, because there's no other conditions that would, make you have to pay it back, or have something else that you have to do.
All right.
The other thing that comes up, since you said security deposit, the other thing that comes up with the first and the last is sometimes tenants don't appreciate that sales tax needs to be a part of that component as well. So you shouldn't just be paying that security deposit. Certainly the last month's rent ought to have sales tax associated with that that's been collected. That's not really your problem as the tenant. If they don't, it's the landlord's problem, but don't be surprised if you do see that.
Right.
Sorry, MP, I didn't mean to cut you off.
Oh, no, actually, the sales tax is a great segue into kind of my next question, which is the related party leases. The lease, if you're the landlord and you're the tenant.
Be both. So if you're leasing to yourself, you still need a lease. Why? Because Morgan & Morgan are for the other people. So if something happens, we need to show that there is a proper lease agreement and for your liability protection. So if you are occupying the space that you own, you still need a proper commercial lease. You may not need all these fancy provisions that Jackie has carefully crafted like a ninja with a sword, but you do need some baseline operating agreement or lease agreement that is charging a proper rent. You do have to pay sales tax to yourself. You can complain about it. It will not stop it. It doesn't mean you can't charge rent. You still have to do that. But that is going to really go miles in solidifying your liability protection as the landlord of owner of that building. So it's important, even if you are occupying, that you are leasing to yourself, that you're actually paying that rent, not just saying that you pay, not just putting it in the lease and then never actually doing the transaction. So.
And what about the fair market value of the rent? What if I'm leasing to myself? I can pay like 50% of fair market value, right?
That's also not going to get you any liability protection, but that's probably the question of the day every time we do this. When people start, after you stop complaining about sales tax, the next thing you do is come up with all the things that everyone else has already thought of that the Department of Revenue is onto. So that lease does need to be at a fair market rent. You might be able to get away with shaving a little bit off, but you're not going to be able to cut it in half. You could be more generous and not have accelerator provisions in the lease agreement like you might with a third-party tenant. But again, the more that lease looks like a traditional lease that you would have with an unrelated party, the stronger your liability protection is going to be if something happens.
Yeah.
And I have to say that lease agreement becomes extremely important if you have maybe different ownership percentages in the entity that is occupying the space versus the entity that is a landlord. So it may be a little bit easier if you're 50-50, let's say, owners on both the building and the business, but you may be 70-30 on the business and then 50-50 on the building. And that typically always works to advantage of one of the owners and not the other one, depending on, if they want more bigger rent deduction on the operating entity or smaller rent inclusion on the landlord holding entity. So that becomes extremely important. Are there any particular provisions that are kind of different on the self-rental that you would include that you may not include otherwise? Is there anything special there that?
I can't think of anything special I'd include. It's really more what you can shave out in terms of, some of like the indemnity. You don't need to put it from the left pocket to the right pocket. So, there's a lot of that you can eliminate or at least minimize so that it's not so cumbersome. But it's so important to have those agreements, particularly if you've got ownership consistent with that operating company and no mortgage. A bank's going to require some kind of lease agreement. So people will at least schlock something together for that. That's not always the best way to do it, but it is at least possible. So.
Right. And that is something it's a good point that you mentioned about the banks requiring it, because a lot of folks who are buying commercial properties are surprised when at the 11th hour, it never fails, the lender comes back and is saying, okay, well, where's the lease? Well, why are you asking me tomorrow's closing? Why are you asking me now? But it's going to be required, so get ready.
And I try to tell people at the beginning of the process, like, oh, well, they didn't ask for it, so they don't want to spend any money on it. So we won't do that now. Okay, so it'll be pants on fire later.
they also don't require a survey, right?
Right.
But that survey exception better come off the commitment. you know.
It's my second favorite. And it's like, you don't have to have a degree to go to law school. You just have to have a bachelor's. Like, okay. So,
Exactly.
you know, so some of those things are a little bit of a dancing in a circle, but like I said, Marina, I don't really think there's anything that you need to put in there to acknowledge that it's a, you know, interrelated party that's the tenant. You might not have so much security deposit.
Please.
The other thing I will say though about leasing to yourself is you might want to be cautious about what you include in rent in terms of utilities and things like that, because that gets a little dicey on what's included in sales tax, and then people are just mad. So you want to make sure you have a good handle on that, how those things are being paid, whether they're being paid by the tenant or being paid by the landlord, like internet or, you know, water, power, things like that.
And the improvements as well. This is also where you do want to outline the improvements, because from the tax standpoint, your ability to deduct them or depreciate them may be better on the operating entity than it is on the land holding entity, because you may have more operating income. So you're able to take that section 179, 100% depreciation for the improvements. So you may want to write it in where the improvements are to be paid by the tenant that's an operating entity. So it's just part of the planning and the strategy on that end.
Yeah.
And I do think a lot of tenants are surprised to learn that sales tax is payable on everything that you pay the landlord, less than except that security deposit. So you know, common area maintenance and things like that are going to be included in what is taxable. So if it isn't more beneficial for you to cover that as the tenant and to leave those with the landlord, you know, that might be more beneficial from just a sales tax savings standpoint as well.
Yeah. Definitely. What else you got? Are you rounding home?
I think that was it for today. I didn't want to get too carried away. I swear there could be a part 2, because there's so many other stories to share and considerations to make, but I didn't want to you know, I didn't want to overdo it.
And speaking of stories, no, it's a good transition. Speaking of stories, there are a couple things I want to share in my experiences over the time that I've been doing this that are not necessarily things people think about when they go into it. So I represented a client who I didn't review the lease before she went into the space, of course, because that would be too much fun. But she came to me for a modification of the lease agreement back in 2000, maybe 9, when the economy was down, and her lease was with a huge national landlord. One of those leases that's like, I don't care, they will come after your great grandkids for the money. Like, they keep really nice properties, but they don't care what your sob story is, you still gotta pay. I always like to caution people about those leases before they get into them, but this opportunity I wasn't afforded. So what had happened was their lease was based on traffic estimates for a new shopping development. That shopping development was put on hold because of the economic situation. And so foot traffic was a fraction, like 10% of what was estimated, which is how they based the base rent. So she wanted to go back to the landlord and renegotiate that base rent and say, okay, well, you said foot traffic would be 100,000 people a day. It's 10,000 people a day. Can we please modify that number? Based on who the landlord was, of course, the answer was no. But they did give her some abatement of rent, but tacked it on to the end of the lease. So they basically just deferred it. She still had to pay it ultimately, but we did get her at least a break during the immediate cash flow crunch. But if you do have a lease based on something like that in a new area where the development is being done and it's not finished yet, that's another thing to keep an eye out for. It doesn't happen a lot, but it was a huge impact. And with a simple negotiation of those terms ahead of time, there would have been a lot different outcome for her. That business ultimately sold because it was too cumbersome to remain in that space. So when the new business owner took over, they renegotiated with the landlord and moved. So you hate to see that. It's unnecessary if you can get ahead of it. So, you know, those kind of things. And, you know, I know you talked about your restaurant with the bathroom situation. That's, you know, those things, the issue is if you are Joe Schmo tenant, like that sounds crazy. That sounds like that would never happen. But if you sit in our chair all day, all we see are the crazy things that aren't supposed to happen. So Marina's constantly accused of being cynical. But it's hard to not become distrustful of, like, okay, where's the problem? Where is it going to come? And that's not because we want to make problems. It's because we've seen them. I don't know what it's going to be, but I know where the problems can erupt from. So that's why we look at things like those indemnity provisions and the default provisions. How do we get you out? How do we get you moved? How do we get you compensated? Those are the types of things that we want to be mindful of. What everybody else is worried about is, you know, how much fee and how long am I there and what's the rent escalator? Those things are important too, but that's not where the disputes happen. Nobody's in court fighting about their escalator. It's 3%. You either agreed to that or you didn't. You know, I'm not saying it never happens, but that's not where the surprises come from. It's to the back of the lease and the part you don't want to read. So
right. Or the minutia in between the 35 pages or so. And like you said, nothing becomes a problem until it does. And I feel like a lot of times people look at lawyers like we are creating problems.
Mm-hmm.
But it really is just a matter of us being highly sensitive to potential risk because we've seen it so many times. This may be your second or third lease, but this is the second or third lease I've looked at this week. So it's, you know, that's why, that's why we take this angle of caution. Sometimes what people believe to be an abundance of caution. But it's for good reason. So
if I had $1 for every time somebody said, "Oh, Jackie's too cautious," well, you know, you can only bang your head on the ceiling so many times before you just duck.
Right. And I seem to stumble into these weird law school hypothetical riddles for whatever reason. Joanne can attest to this.
I'm afraid to send you any work.
Yeah. So that's another reason why I'm so cautious. But I think at the end of the day, you'll be happy. It is, again, kind of like an insurance contract.
Exactly what it is.
You hope to never have to enforce or lean on one of these provisions, but in the event you need to, man, are you glad that you negotiated that and that you tweaked it to what was for your benefit or to the best of your benefits? So
absolutely. Well, thank you so much, everybody, for your attention. We hope that this has been super helpful. We will be back with more topics. We are off next week because of Labor Day, but we'll be back the following week, and this dynamic trio will continue to serve. If there are topics that you'd like to hear about, you're welcome to email us or drop us a line on our website or on our Facebook. You can also find these recordings on our Facebook, on our website, and on our YouTube channel. So if you have suggestions, let us know. We look forward to talking to you, and we'll see you in 2 Tuesdays.